This courtroom showdown is anything but ordinary. Meet Mariah Lopez, a woman once granted a second chance through community supervision after being convicted of injuring an elderly person. But instead of redemption, we're watching her spiral deeper. From missing drug tests to allegedly assaulting another inmate while in jail, Lopez now faces a brutal reckoning. The state is done offering leniency, and this time, the consequences could be serious prison time. As you'll see, the judge isn't pulling any punches. Why did she reject a plea deal her own lawyer pushed for? Why did she refuse to testify when it mattered most? And how did a jailhouse altercation become the final nail in her legal coffin? Let's break it all down, twist by twist, lie by lie, and verdict by verdict. This one's wild, so don't blink.
3. State of Texas versus Mariah Lopez. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Peter Calderola for Ms. Lopez, Your Honor.
Are you Mariah Lopez? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Mariah Lopez who was placed on community supervision in 2022 CR 8673 for the offense of injury to an elderly on March 20th, 2023 for a term of 6 years? Is that you?
Yes.
State.
Violated condition number 1, on or about the 9th day of February 2024 in Bexar County, Texas, the defendant, Mariah Lopez, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
Did you catch that? Lopez just pled not true to assault, even though we're about to see actual video evidence from jail. It's a bold move, especially when her probation is already hanging by a thread. Remember, pleading not true means she's ready to battle the state's claims in court and risk losing big if she's found guilty. Why take that gamble, especially after her lawyer confirmed she rejected a deal? Maybe she's hoping to call the state's bluff, or maybe she underestimated just how damning the footage really is.
Not true.
Violated condition number 2, on or about the 19th day of January 2024 in Bexar County, Texas, the defendant, Mariah Lopez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 14G, on or about the 19th day of January 2024 in Bexar County, Texas, the defendant, Mariah Lopez, did then and there fail to register, attend a state-accredited battering, intervention, and prevention program with approved agency in violation of condition number 14G.
How do you plead to that? True or not true? Not true. All right. And with regards to the other violations,
Oh, I'm sorry, Judge. We waive and abandon the other violations alleged in the motion.
any objection?
No objection, Your Honor.
All right, state, you can call your first witness.
Your Honor, I call Deputy Casares.
Your Honor, and if I may.
Here's where things get tense. The defense confirms there was a plea offer, one that included dismissing other charges. Her lawyer urged her to accept it, but Lopez said no. That raises major questions. Was it pride, denial, or something deeper? Rejecting a plea when you're facing multiple violations is risky, and the judge knows it. You can already sense the frustration in the courtroom. This isn't just about one mistake. It's about a pattern of resistance.
Before we proceed with testimony, for the purposes of the record, there was a plea offer in this case, and it was against counsel's wishes.
Oh, no. If you are going to put on the record what the plea bargain agreement was.
I wasn't going to put the plea on, Your Honor. I understand you're not allowed to be privy to the plea.
Oh, okay.
Just that there was a plea offer made. I advised my client to take the offer. I thought it was a reasonable offer. There were some cases that were going to be disposed as part of that agreement. However, the client has rejected that offer.
Okay. All right. Do you wish to continue with this contested hearing? That's either yes or no. What's going to end up happening is the state has read the violations. You've said they're not true. So now the state is going to call witnesses. They're going to call this first witness. You can turn around. That's the witness at the back of the courtroom. They're going to come and testify. So do you still wish to plead with your pleas of not true? Or do you wish for the state to go forward with their case and call a witness?
I didn't know. I didn't know we were doing this. I'm sorry. I didn't.
Well, you were here yesterday and you knew we were doing an MTR and you didn't want to come from the jail. So it took us a while to get you to come from the jail. I had to sign an order for you to be brought over from the jail. So you were brought back today for a contested MTR hearing. What will happen in the hearing is the state is going to call their witnesses. If they present evidence and I find it true, then I will find it true. Then we'll go forward with whether or not I revoke your probation or not. So the question for you is, do you wish to continue with your plea of not true? Yes or no?
This moment is telling. Lopez says, I didn't know we were doing this, but the judge isn't buying it. She skipped court the day before, had to be forcibly brought from jail, and now claims she's surprised? Judges have little patience for last-minute confusion, especially when hearings like this are set in stone. Her body language screams discomfort, and her uncertainty could cost her dearly.
Yes, sir.
As part of your duties, do you recognize what I've marked as State's Exhibit 1?
Yes, sir.
And how do you recognize it?
That's the video from our overhead camera. They're in South Tower booking.
Okay, and how do you, did you have an opportunity to view this?
I did review it. Yes, sir.
Okay, and how do you know that you reviewed it?
I signed and dated.
Is this a fair and accurate copy of the recording that you accessed in regards to this case?
Yes, sir.
Okay. Your Honor, I offer State's Exhibit 1. This is for the assault.
Okay. I have no objection, Your Honor.
All right, state's exhibit number 1 is admitted without objection.
Do I have permission to publish this, Your Honor?
Yes.
And so aside from providing the video to the investigations part of BCSO, did you have other interaction with this case?
I interviewed both and I'm in charge of booking, so I'm aware of the inmates that are in our section.
Okay, and so do you recognize the defendant?
Yes, I do.
And how do you recognize her?
She was one of the inmates in booking that day.
Okay, and was she involved in an altercation?
Yes, she was.
And what happened?
She was in line to be transferred to the main jail. She walked away from the line and just went straight to Latrell and started striking her.
Here it is, the bombshell moment. The witness confirms Lopez walked away from the jail transfer line and attacked another inmate, unprovoked. No argument, no warning, just violence. And this wasn't speculation. The overhead camera caught it all. Once video enters the courtroom, it's game over for most defendants. So at this point, the assault violation just went from alleged to confirmed. Did Lopez truly think this wouldn't be used against her?
February 10th, 2024.
Okay, and where did this happen?
South Tower booking.
Okay, and is that in Bexar County, Texas?
Yes, sir.
I pass the witness, Your Honor.
Any questions?
Sergeant, you were present that day at the jail,
Yes, sir.
and you saw, you have personal knowledge that Miss Lopez assaulted that the allegedly assaulted that other inmate,
Yes, sir.
and so you don't know that if the other inmate maybe had said something to Miss Lopez to get her, to kind of aggravate her.
She wasn't near her.
So you don't know what their interactions were beforehand, do you?
I do.
No further questions, Judge.
All right.
No further questions.
Is this witness excused or subject for recall?
Excuse from the state, Your Honor.
Right.
Excuse.
All right, thank you. All right, so with regards to the violation of condition number 1, state has already presented evidence on violation of condition number 1. Is there any evidence. And of course, defense, you don't have to present any evidence. Is there any evidence you would like to present on violation of condition number one?
None, Your Honor.
All right. With regards to violation condition number one, the court is going to find violation of condition number.
The verdict is in violation number one, true. That means the court officially accepts that Lopez committed a new assault while on probation. And with that single ruling, the entire foundation of her community supervision collapses. Probation is built on trust and compliance. And once that's broken, judges waste no time. The next question, how harsh will the sentence be?
Number one, true. State, are you still proceeding with violations of 2 and 14G?
No, Your Honor, we'll waive those.
Any objection?
No objection, Your Honor.
All right, then the court will hear requests from each party. What would you like to see done with regards to the motion to revoke?
Your Honor, we're asking for the 5 years. The defendant made a bargain to for deferred initially. She was unsuccessful on deferred. Her sentence was reformed for community supervision. And she agreed to the 5 years. She didn't do great on community supervision. She picked up a new offense that brought her to the jail. And then once she was in the jail, she picked up another new offense. So, Your Honor, at this time, we're asking.
The prosecution isn't pulling any punches. They're asking for the full 5 years. And why? Because Lopez already got a break when her original sentence was reduced to community supervision. But she didn't just violate once. She racked up multiple violations and committed new offenses while in jail. That shows a clear pattern of disregard for the court's mercy. When even your own lawyer doesn't argue for leniency, you know the situation is bad.
Credit for any time served, and there's to be no contact with the complainant in this case. And in the assault case, what is the name of the complainant?
Littrell, Your Honor. Sorry. Rebecca Littrell. It's
All right, and there's to be no contact with Rebecca Littrell.
it's spelled a little unusual.
All right, yes.
Rebecca. Littrell is Luttrell.
I'm sorry, L-U-T-T.
Luttrell.
All right, and there's to be no contact with Rebecca Littrell. All right, I'm showing you what's in the court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand? All right, because this is a felony conviction and because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
And there it is, 5 years in prison, an affirmative finding of family violence, and zero room left for appeal. Mariah Lopez had every chance to turn her life around. Instead, she rejected a plea deal, ignored court orders, and added more charges while behind bars. In the end, the judge had no choice. This case is a powerful reminder that second chances don't last forever, and in court, your choices echo louder than your words. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next one.